Good evening, friends. Every day I receive calls from people who are usually victims of builders, not always. Sometimes they are victims of bank frauds. Some of them are just RTI activists trying to unearth corruption and they want help with RTI application or RTI appeals. Some of them have been refused or denied justice or refused information, so they want help. People approach me for appointment matters or other service matters where they have been denied justice in recruitment for government jobs. Most of the cases I can only help them with some sort of generalized advice. A few of the cases I get involved in at some level. I devote time and energy. Many times I tell people's stories, or I just guide them through the process, step by step. And it usually involves my staying in touch with them for months or years as their case progresses through many twists and turns. So I'm familiar with a lot of these things. I'm not a huge expert, so there are times when I consult with others who have domain knowledge. I consult with lawyers who are my friends. Sometimes I refer them to these lawyers. I consult with domain experts who are experts in society matters, that sort of thing. So basically, I'm a networker. I network people. I try to assist with networking, with contacts, and about 19 times out of 20, such activities bring me no revenue, and some of the times they actually are an expenditure head, and I cannot in all decency start asking for taxi fare and stuff like that from people. So I end up spending from my own pocket rather than asking for petty expenses, because I find that quite ridiculous. This is basically how I live. This is basically what I do. And for those of you who are wondering how I survive, to a fairly large extent, I am consuming my fat, so to speak, which I accumulated when I was a businessman. I am living off the resources to a very large extent. The resources that I have stored as fixed deposits, etc., are now being consumed. To many people, that may seem like an alarming way to live. To me, it's just a normal way to live. I don't find it alarming, because from time to time, between paying assignments, I find it quite reasonable that I should consume my savings, and I do not consider it as scary as some people might think, because I consciously do not take loans. I do not have a credit card lifestyle. I do not live lavishly. I live quite frugally, and so does my family. And so, this is my set of values: to put the work ahead of the money. It's not that money is not important. Money is important, and money must come. In the long run, you need money. But in the short run, I feel it is disastrous to the work if you connect the work to the money too closely. You need to connect the work and money very loosely together. That's my way of doing things. That's my philosophy. It's not even a philosophy, it's just a way of doing things. I don't think it too much. I don't overthink it. I just do it. Anyway, I rambled a little bit, but the point I was trying to make is I get a lot of people calling me with respect to solutions, asking or discussing solutions to issues that they have. And that is why judiciary figures in a fairly big way in my discussions. Because judiciary is in the end a solution provider. If you have been denied your rights, any kind of rights, be it consumer rights or your civil rights or even your marital rights, there are occasions where men who have been wrongly accused of domestic violence, etc., or alternatively women who have been deprived of their alimony payments, maintenance, stuff like that. Okay, assets, part of a justifiable part of the marital assets, that kind of thing. So from both men and women's side, I do receive calls. We have these discussions about how family courts are conducted, about how their litigation is being conducted, about what is happening, and how they are basically stuck in a litigation that's going nowhere, in a fruitless litigation that's never ending, and a vicious cycle where the combatants cannot see any light at the end of the tunnel. So there are 2 or 3 major things I take from this. From all my interactions with such people, from all these ongoing interactions with litigants and with lawyers with whom I consult about their cases, the overall picture that I get is one of insufficiency of judiciary. Judiciary is insufficient. Judiciary is like the heart of a mouse fitted into the body of an elephant. It fails to supply blood everywhere. It is woefully insufficient for the needs of the Indian people. And perhaps in an effort to hide its own insufficiency, this institution called judiciary either consciously or otherwise deprives large proportion of the population of access to the judiciary itself, or of sustainability of their litigations. Let me repeat that in a slightly simpler way. This institution called judiciary, being insufficient to meet the needs of the Indian people, the people of India, cloaks its insufficiency by actively depriving people of access to itself, or it gives it access to itself but not access to justice. It allows the litigant to enter the gates of the court but not exit the gates of the court. In effect, it makes them prisoners of the judiciary for most part of their lives or all of their lives. It traps them in a process from which there is no exit. Let me now go on to elaborate on this statement. Let us begin with a large part of our population who has every reason to go to court, but they are almost doomed to not get justice, and that is senior citizens. A senior citizen aged around 70 is usually nowadays wealthy. I'm speaking of the middle classes and the upper middle classes. I will not speak of the lower ones who may not be wealthy, but in the upper middle class and the middle class, and of course the wealthy class, the truly wealthy class, multi-crore-patis, people at the age of 70 have accumulated good amount of assets. They have large amount of assets to distribute among their children or in any way they please distribute among their families. They may also have litigations because of their dealings, because they were wealthy and powerful people. When you are wealthy and powerful, you may have cause for disputes. Disputes arise for assets. It may be marital disputes. It may be disputes with brothers. It may be disputes with former business partners. It may be disputes with people who are trying to take over your company or take over your assets or take over your NGO, or people who have misappropriated from you and your family. Banks often misappropriate wealth in the name of portfolio management. Banks and financial institutions misappropriate, misguide, basically steal from you. They take your investments and they churn them, and instead of growing your investments, they deliberately shrink your investments in order to earn a commission and divert your wealth into their own bank accounts, into their own pockets. So there are multiple reasons why aging or aged wealthy people must litigate. There may also be reasons why they may litigate or be litigated against. There may be criminal complaints against them, and so on. Now, these people, the aged, let us take that a hypothetical age of 75. If a litigant is to go to court and file a civil case, the likeliest possibility is that he is not going to get the outcome of that civil case for the next 20 years or 25 years. That is almost an inevitability. Which means if he is 75 years old, it is almost certain that he will have to live to be 100 if he wants to see a case come to its logical conclusion. Most of the people will not be in full possession of their physical and mental faculties at the age of 100. Most people will not be in enjoyment of their physical form at all. They will have passed. Most people, if they have not passed and if they continue to be in some form, some kind of physical and mental state of health, may not care what happens. They may have gone beyond caring in 20 or 25 years. So there are multiple reasons why the cases of aged people should be resolved by the judiciary in a year, 2 years, 3 years, 5 years at most. If you are 75, resolve the case before it is 80. Give a judgment, not just interim orders. Give a judgment. If judiciary were to do that, then it could truthfully say that it is available to aged people, to senior citizens. The fact of the matter is that judiciary doesn't do that. And therefore, I am saying that for anyone over 70 or 75, the remedy of filing a civil case is, for the most part, not a realistic remedy. There are cases where you seek interim reliefs and you are really after the interim, ad interim and interim reliefs. You are not there for the final reliefs. You are not there for justice. You are there for orders. You are there to seek interim orders. Now this amounts to interference in society and abuse of what's the right word? Abuse of the judiciary. Just abuse of the jurisdiction of that relevant court. Should not be done. But it is done. People don't want final order, they just want interim order. It's abuse of judiciary. But it's done. It's routinely done. Is it that the judges can't see through such strategies? They can. They often can. But they allow it to pass. They don't mind. They don't mind being abused. They are used to. Judiciary is used to allowing its own abuse. Especially by the rich and famous. Especially by the wealthy and the influential and the powerful. It allows itself to be abused because the wealthy and the powerful have the means to engage senior counsels. And for some reason, when senior counsels step into the court seems to lose its critical faculties. Judges seem to lose their critical faculties or loosen the standards that they set for themselves. They loosen the standards that they set for themselves while dealing with cases or the standards that they set for litigants to come before them. Suddenly, you see a vast array of nonsensical excuses being made by judges for accepting bullshit in various flavors and giving interim reliefs. Judicial sounding, official sounding, genuine sounding bullshit. Smells, stinks. You can smell it, you can see it, but they do that. And they seem to do it with a very, very, very straight face. The thing about age and authority is that it gifts you with a straight face. It gifts you with a face which enables you to dissemble. And this is unquestionable authority. If you question them, you stand the risk of being prosecuted for contempt. So this happens a lot, and judiciary is cluttered with a lot of nonsensical cases that wouldn't be admitted were it not for the sheer wealth and the sheer power and the sheer influence of these litigants. But to come back to this question about people who are aged, judiciary is by and large not a place for an aged litigant. He is not going to see justice. It is not a place for civil or criminal litigation even, because he will never get to see the end of it. It goes on and on. In terms of criminal, when he is a complainant, in any case, he must not prosecute. It is the state that prosecutes. And there are so many loose linkages between enforcement agencies and public prosecutor. It is as if the state has a very negotiable will to prosecute. And rather than the judiciary's will to do justice or the judiciary's will to deliver the right orders and judgments, criminal matters are dictated more by the state's unwillingness, on the one hand, unwillingness to devote resources to a serious investigation, to a serious gathering of evidence, to a serious presenting of evidence, to a serious prosecution for the most part. And so there's not so much that judges can do, or there is not so much accountability that we can put upon the judges. Of course, there is always a question of the complainant also being able to put up his own lawyer, but there's a very limited scope for that. There is some scope of having your own lawyer to assist the prosecution. Assuming even that is the case, assuming that an aged litigant is still not likely to get justice, is still not likely to see the person complained against go to jail, though he may go to jail in terms of judicial custody or something like that. Usually judicial custody wise he may go to jail, a person may go to jail, but he is unlikely to live to see the sentencing. So for a senior citizen, most of these judicial forums are not available. Now, what is the proportion of what is their proportion of the population? I would say senior citizens constitute about 15 or 20% of the population, but they are the ones with the most cause to litigate. And I still talked only about the wealthy. Let us talk about the poor. The poor of any age do not have the means to litigate. The poor do not have the means to litigate at all, or at any rate, they do not have the means to litigate successfully. If a poor man is pitted against a rich man, I said this before, I'm saying it again. I said that the social contract with the common man is broken because the judiciary inevitably favors the rich man over the poor. And it's a very unlevel playing field. It's a very unfair playing field which is biased towards the wealthy, the powerful, the one who can afford legal assistance and counsel. The poor man who is at the mercy of every small lawyer, small, ill-trained, inefficient, mercenary possibly, immoral, or, well, it's patchy, it's a very patchy terrain, but he's at the mercy of the lawyers. How can he hope to get justice when the judge regards the words and the representations of a senior counsel so much more seriously than the words of a common mofussil lawyer, a poor man's lawyer? And therefore, the poor man has almost no scope of being in court. So what is a poor man? Let's define this. Anybody who's earning 100, 200 rupees per day and must support himself on those 100, 200 rupees and his family as well. So anybody who's earning in the range of 6,000, 8,000, 10,000 per month cannot hope to go to judiciary. Anybody for that matter who has to work 8 hours, 12 hours per day to keep his family fed cannot afford the luxury of going to the judiciary. So that eliminates a large number of our young people, a very large number of our young, middle-aged and old people. It just eliminates them entirely. So how many people, what proportion of people have hopes of getting justice from this judiciary? Oh, and by the way, there is this thing about the technicality of the judiciary. Corporates have the bandwidth. Corporates have the intellectual bandwidth, the managerial bandwidth to go to judiciary and prosecute and understand what is going on, at least halfway. I mean, I see corporates doing half-witted things, doing idiotic things, but by and large, corporates have some kind of a bandwidth. They are mentally equipped to go to the judiciary. But the common man, the common woman, the housewife, they are at the mercy of lawyers, of judges, of court procedures, of the changing winds of benches. Every bench assignment that changes is like a change of direction of the wind where their litigation is concerned. And they just drift around haphazardly, getting lost, getting sometimes more and more lost, and sometimes with very happy results. They suddenly come out, someone wins, and then something goes into appeal, and then again it's all confused, and there is a loss of agency. They are not in control of their own fate. So let me close with this. Judiciary cannot be a place where there is loss of agency of the litigant, where a litigant is deprived of his own agency, his own control over his destiny. The overly technical nature of judiciary, the preponderance of procedure over substance, over merits, the preponderance of technical aspects of the law over the intent of the law, the judicial intent, the preponderance of court rules and court form over the lives of the litigants, the quality of life of the litigants is so horribly skewed. It's such a distorted scene that the judiciary has. It's such a distorted attitude. It's such a distorted playing field that one is forced to come to the conclusion that the judiciary is not available for 95% of our population. Jai Hind.